case, Your Honor. It's not being used for a drug draft. Basically, the whole issue had a host when my client had hosted a memorial gathering with friends and family. And they had warned the police at the time of this event, of course, because they just wanted to make sure that the city was aware if there were any issues. And basically, my client, Mrs. McAllister, was his wife, had received a noise violation ticket, which we had handled previously. This matter, Your Honor, is a completely separate ticket that came as a surprise to my client because there hadn't been any noise issues at the time of it being issued. And basically, Your Honor, we appeared originally, counsel and I had agreed for the first adjournment of the matter because my clients wanted to discuss directly with the city. My office had previously discussed with the city a few months ago as well, and then there were subsequent discussions that my client wanted to discuss directly with the city without both counsel present. So that meeting date was scheduled the second day after our original hearing here in court. So I had contacted counsel to request an adjournment so that our clients can go ahead and discuss directly. Counsel did not object to that adjournment, and unfortunately, there was a misunderstanding as far as that getting translated over to the court. I know my client be held accountable for that. If anything, I'll take the blame for that. I have to take the blame for it. So basically, at this point, my client does want to just get the ticket because again, there is no commercial use of this property, of this driveway whatsoever. So he does have valid defenses and meritorious defense in this matter, and there is good faith for this default to be set aside.
Your Honor, the strongest evidence of the commercial use of this property come from the defendant's own mouth. There is a website, there is business, there is promotional materials that he's posted on numerous social media channels. The memorial event was something he posted on TikTok inviting anyone who saw the video to. There were people in staff t-shirts, including the defendant. This is the idea that we're going to argue to the court that this is not a commercial business flies in the face of every single word that has come out of the defendant's own mouth. It's not remotely true. And so for the court to set aside the default based on a misunderstanding, I could see where the court would come to that conclusion. But the issue is there's not a meritorious defense using the defendant's own words about what the property was being used for. And I understand that there's going to argue that they haven't been using it recently, but the problem is that the businesses are still active businesses with the state. The videos were still posted, and what we would have would be the defendant's own word that he's not going to continue to use this property as a commercial property, except after the last time they told the township they weren't going to do it, they continue doing it because we got to do phone noise complaints. The issue is that the township has asked them to provide plans for what they're going to do with the driveway. We had a meeting where council, the McAllisters, myself, the building department were all present. And during that meeting, the township made it very, very, very clear to the McAllisters that the way that the township is going to be comfortable that this is not going to be used as a drift track any longer is to remove the portions of the track that you can drift around, i.e. all of the curves in the corners. The plans they submitted were, we're gonna leave the driveway as is and we're just not gonna use it. The township was not agreeable to that, obviously, because that was against our entire position. And we've been waiting for months now for them to submit new plans. It's been nothing but adjournment request, dragging it out. The meeting that they scheduled in the building department, they canceled at the last minute and asked to reschedule it. The township's not asking for engineer drawings, but for whatever reason, defendant seems to think that that is what the township's requesting, despite the fact that the township has repeatedly said, we just need something that can be rough sketch, like just nothing formal, nothing engineered, but just something to give us an idea of what they're proposing so we can have some discussion. We can't have discussions when their plan is, we're gonna leave everything as is, and we're asking you to trust us when we've given you no reason to trust us. Then we're gonna keep our word. So there's really, the way that we conveyed, should have conveyed to the court that the quick case being adjourned was by notifying the court that didn't happen. And there's no defense to the ticket. There's obvious commercial use of the property from the defendant's own words. We would ask the court to deny the motion.
All right, so counsel, even if I give you the good cause for the default, I don't see the meritorious defense.
And we also provide some clarity as far as the company itself. That company Sideways is actually a clothing company. And my clients are in the process of getting an actual commercial based drift track in place in a whole separate city with the proper licensing and the proper planning and making sure that everything is in place in order to have an actual drift track. That's not relating to this Van Buren Township property, it's completely separate. And like I said before, the main complaint was from that blood memorial event. Unfortunately now, whenever anyone in the community is hearing any type of noise, they're automatically assuming that it's my finding. That's not the case, because officers have appeared several times to my client's property and they've all showed up and said, why are we here? Nothing is happening. At this point.
So let me ask you this, sorry to cut you off. I'm assuming, I know nothing about drift tracks, but from what Ms. Manarino said, this roadway has a number of curves in it, including like a loop. Is that right? Okay. Nobody puts a driveway in like that. Nobody in the history of mankind puts a driveway in like that. So are you going to be able to establish at hearing that this other site that they've been working on has been in place since before November of 2025?
As the exact timing goes, Your Honor, but I do know that it's something that's been in the works as far as first them having a company that they're working on establishing and building up for this track purpose. And as far as the proposal goes, in order to handle the current driveway that's in place, my client had previously submitted a proposal where they wanted to build different structures on their property in order to make use of this driveway. My client's a car enthusiast.
But it's not a driveway. It's not a driveway, counsel. Under any stretch of the imagination, nobody puts in a figure-8 driveway. They put in figure-8 tracks. Motion's denied. $230 is what you owe us, Mr. McAllister. When you want to pay that? You can. So what's next? I mean, the problem's not resolved.
No, Your Honor, the default's been unpaid. Proceed with filing a motion to remove the driver.
All right.
Thank you, Your Honor.
Have a good day.
Mute your phone.
Heather? Muted. Do you try him?
Mr. Bowden,
what are we doing on Alan? No show?
I haven't seen him yet, Heather.
Yeah, he hasn't jumped on yet, so we'll put him in the no-show pile.
All right, he's an hour late, so assuming he's not coming.
Correct.
All right, if you need me, call me. I'm gonna leave the meeting.
Well, we physically could use you if you're up for it.
Oh, absolutely. Yeah.
Rodney is here and he's thinking.
Beg your pardon?
Mr. Graziani desperately needs help.
Then I will help him.
We appreciate it.
Yep.
You'll come in?
Yeah, it says here, join the breakout room with Angela.
Yeah, I'm not on Zoom, I need him in person.
No, we would really like it in person if you could actually make it.
Judge, I'll be there in 15 minutes.
Thanks. We just want to communicate it to the defendant. Appreciate it.
Yep.
Yeah.
Oh,
What are we doing with Hughes?
I'm just, Jamie,
You got Hughes?
I sure do.
it's the civil correct.
Cross it out. So Graziani is the only one that's out there? How did they send us just one?
We've always only had one on our violation docket.
Oh, this is all violations?
Doc and that just happened within the past couple months, so now we've
Yeah.
learned we need two or three.
Mr. Hughes, can you hear me all right?
Yes, Your Honor. Good morning.
All right. The prosecutor asked me to dismiss the charge from February 23rd and return your bond. I'm
Thank you.
assuming that's okay with you.
Yes, sir.
Have a lovely day, sir. We'll process that and send you a check.
Thank you, sir. Appreciate it.
You done? Can we just dismiss?
Am I
I'm gonna
dismissed,
kick you
sir?
out. I'm gonna
Okay.
kick you out. Yep. Have a great day. Peek on.
Well, that. Take care of these, and then I'll be back. That's interesting stuff out too. And then Elizabeth,
How's your dizzy?
it's still, but Elizabeth Moore.
Yeah.
For that trial, she's like, remember we had asked about doing a Zoom test? She goes, my client's gonna do
Yeah.
one today at 4.
Yeah.
I'm like, I'll leave it for me, but I'm gonna leave your Zoom up and just ask somebody downstairs
Yeah.
to jump on,
Yeah.
just to be host.
Yeah.
And then and so I told her I was gonna do that,
Yeah, that'll work.
yeah.
Mr. Graziani, you're all set on McLean?
That with Miss Avian Janae McLean.
All right, I'll bring her and we'll be out
Thank
there
you.
in just a minute.
Thank you so much.
Mr. Graziani, your appearance for McLean while I find the file.
Okay, thank you, Judge. John Graziani, P number 43387, appearing on behalf of Ms. McLean. Ms. McLean, please identify yourself.
Good morning, Judge. This is Aviana Janae McLean.
Thank you, ma'am. Counsel, go ahead and tell me what we got.
Judge, discussed this matter with the prosecutor, and the defendant is in agreement to pleading guilty to the harassing phone calls. She pledges that she will not call her grandmother again. And if the judge allows, if you allow it, Judge, she'll take it under 771.1, which would be the delayed sentence.
And was
That's
there a
correct, Mr.
time
McLean.
frame discussed between you and the prosecutor, counsel?
It's a 12-month time frame that she offered, Judge.
Thank you. All right, Ms. McLean, did you
Yes.
discuss, can you activate your camera, ma'am?
Yes, sir. Can you see me?
I can. Did you discuss your rights and options with Mr. Graziani?
Yes, sir.
Do you understand those rights and the options they present?
Yes, sir.
All right. And you understand, do you understand the possible penalty for the charge?
Yes, sir.
Understanding all of this, are you pleading guilty to that charge freely and voluntarily today?
Yes, sir.
Counsel, if you would like to voir dire to get the facts to satisfy the plea, February 9, 2026 is the date on the file.
Hey, thank you, Judge. Ms. McLean, is it true that on that date that you made numerous phone calls to your grandmother?
Yes, sir.
And did she indicate she didn't want to talk to you?
No, sir.
No, we spoke earlier, and she wanted you to stop.
Yes, sir. She did want me to stop.
And but you still continued calling her. Is that correct, Ms. McLean?
Yes, sir.
Okay, Judge, I'm satisfied.
I'm satisfied as well. All right, I will accept the plea. And let's see, you're in Dallas, correct?
Yes, sir.
All right. Are you working?
Yes, sir.
Work.
Say it one more time.
Where do you work?
I work for Garter World doing security for Google.
Thank you. All right. It says, I got paperwork here that says you got a file from 2025. Malicious destruction of a building. You're on probation.
Yes,
I
sir.
indicated
That's
that
with my
to Ms.
grandma.
Daniel.
Okay.
Judge,
And it looks like you were just placed on probation this January. Is that right?
Yes, sir. That was with my grandma.
Yeah. How long is your probation? Was it 12 months?
Yes, sir. And restitution has been paid in full.
Yeah. It looks like you already paid off all the money. You just got to stay out of trouble for 12 months, right?
That's a fair deal.
Anything else you got to do for probation?
None that I'm aware of. I do need to follow up with Mr. Grant
Okay.
after this court hearing.
Yeah. Make sure there's no other stuff, no other boxes you got to check to be successful on probation.
Yes, sir. Will do.
All right. Anything else you want me to consider before I sentence you on today's file?
Judge,
No,
she's
sir.
been gainfully employed. She's got an excellent work record. She had a very difficult upbringing. Homeschooling has been thought that it's a lot of people think homeschooling is great. It should actually be a hybrid program. That's my little assessment, but as a result, Miss McLean did not have much interaction with other folks during her troubled childhood, and as a result, she became quite dependent on her family, her mom, and her grandmother, and as a result, it created these problems. And she's gainfully employed. She makes almost $30 an hour. She went to Wayne State for 3 years, and I think she's got a bright future. But like all of us, she may need some counseling, Judge.
Okay. All right. So my concern is it looks like the incident date on this one is 2/9/26. It was after she was sentenced. This could be a violation of probation.
Judge, I realize that. I still believe that she would qualify. You know, I discussed that with Miss Manarino, and she indicated that she could still qualify for 771.1.
Okay, but that doesn't mean she won't have a problem with the probation file.
Understood, Judge. Understood. I explained.
Okay. All right. Okay.
I think quite frankly, it arose out of the same incident of anger and, you know, a little bit of stupidity. But like I said, Miss McLean's got a very bright future.
Okay. All right. Ms. McLean, anything else before I sentence on this file?
Yes. So when you said that it could be a violation, how does that work now? If it is a violation?
Anytime we put somebody on probation, one of the terms of probation is you stay out of trouble, no further offenses. So if you were sentenced on January 6, 2026, but yet this charge came up in February, whoever sentenced you, I'm assuming it's Judge Martin?
Yes, yes, sir.
Okay, so Judge Martin could violate your probation because of this charge I'm taking the plea on. Whether or not she does or not, I have no idea. I don't know what conversation she had with you when you were sentenced. I'm just telling you.
So
that-
wait, I have a question, Judge. That incident for February 9th, I was already in Dallas, Texas, and had no communication with her. I did communicate with my grandma starting from Halloween up until my court date in January, but I never made contact with her in February because I was
Okay.
already in Dallas, Texas on January 10th.
Okay, so.
It could just be because of the filing with the delay, but I can guarantee you I didn't have contact with her after
Okay.
January 10th of this year.
Okay, well, if that's the case, you probably won't have any problems with your probation file. I just have to warn you because my incident date is February of this year.
I understand. And
Okay.
with that being stated, with the probation hearing, if it is a violation, how would that then result for me?
That's on that file. It's not going to change my file at all.
Judge,
Okay.
if Judge, I apologize for interjecting. If you don't mind, can I speak to Miss McLean again? Because I explained some of these things and I obviously didn't do a good enough job, sir.
Yeah, yeah. And based on what she's telling me, it might not be a problem, but I just have
I don't
to.
think it is either, Judge, but I simply want to clear that, you know.
All right,
Thank
take her
you.
back in the breakout room.
All right, I'll put you back in.
Yeah. Yeah. Ms. McGoldrick, come on up to the podium for me. You're here today for a dangerous dog misdemeanor from August 5, 2024. The prosecutor wants me to dismiss that. I'm assuming that's all right with you. Okay. That's the good news. Unfortunately, the bad news is you owe us money on some other stuff. So let's see if we can talk about that.
I did some emailing.
Are there any other files? Hold on, man. Hold on. Are there any other files with her name on them?
I can look. I looked earlier.
Judge, what's the last name, please?
First name Cynthia, last name McGoldrick.
MCG.
MCG. Looks like she's got 4 or 5 files in warrant status, but they didn't send the files in.
Yeah, there's no other files for it again.
All right, so I've got a 2019 Van Buren Animal at Large, 2019 Van Buren, I'm not even sure what that stands for. Something with an animal charge. 2 charges, Van Buren 2021, unlicensed domestic animal in violation of technical requirements. And all those are in warrant status with money due. All told, because not only those, we've got some other files that you owe us money on. All told, you owe us over $2,000. Okay. Since when? Because as of April 7th, we've got no record of any payments.
I already made about 3 payments of $200.
When?
The 10th of each month.
Okay, so my records don't reflect that. You sure it's not some other file? Okay. So how much are you making?
I make
No, payments, how many?
$200 a month. I think I've made 2 or 3. And I know I started off with the $50 one that you have to do to get into the payment plan.
And when's the last one?
I just made one.
Like today?
Like 3 days ago, 4 days ago or something, just to make sure it was before the 10th, sometime before the 10th. I never got something that said what my payment plan was going to be.
The only way that happens is if you come in here and make the payment plan and ask for paper to leave. So here's what I'm gonna do. Today's file is dismissed. Go downstairs, make sure they have record of the payments you think you made, and get your plan when you walk out, you have paper.
Yeah, I'll send you.
All right, go downstairs. You're welcome.
If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.